So, we're back in session. I had asked the city to confirm whether or not there has been a prior adjudication for illegal advertising of short-term rentals.
Yes, Judge. Do you
And
mind if he passes it up to you?
I rather that you
I could read.
read it for the record
Sure.
so that everybody is aware of what
Sure.
you're saying.
It's June 6, 2018.
Okay,
I-
wait a second, so
Sure.
we can all follow what you're saying. On June what?
June 6, 2018. It was a 6 p.m. hearing. He was found guilty. He had an abatement date of July 31st.
What was he guilty of?
The advertising.
Okay,
That's what he's contesting.
okay.
If Your Honor would like, I can pass up the actual adjudication that was found by the special magistrate, which was Judge Cazot. And if Your Honor requires extra confirmation, we also pulled up the tape recording from that date, which talks about service and the adjudication that was imposed by Judge Cazot. And in addition, Judge, he wouldn't have been found guilty by any magistrate if service was ever an issue.
Okay, and that was in 2008.
2018.
18, I'm sorry.
Sorry if I said
Okay.
anything separate.
June 6, 2018, and the advertising related to this particular residence?
Yes.
And there was no appearance on the part of the property owner at the hearing?
In correct, no appearance.
Okay,
Did you need to see it or?
no, it's
Okay.
available. I accept what you're saying on, I just would ask if Mr. Galinsky would like to see the video and respond as to whether or not it's an accurate reflection of what happened that day.
The only response that I have to that would be Andrew Dixon's letter dated November 19th, 2015. When was the hearing?
2018.
Not even a year ago.
A year ago? Well, Frank Wallen has been my attorney during that time, and as far as I know, there was no hearings that were ever missed. There was no hearings ever conducted. I would have received, he is my representative, so any type of hearings or notices would have been sent to his office because he was already representing me. And there's no recollection I have from myself or through my attorney that we were ever notified that there was a hearing on that date.
Well, you're certainly free to go through the video and see for yourself. There was
What
no
would-
appearance.
What would the video
The
tell me
video
about
would
that?
tell you that the court officer certified that proper service was conducted. I'm sure that there
would-
was a presentation made before the magistrate, finding nobody to oppose it. I'm sure that that's how the
Would that
violation-
include notification to my representative, my attorney?
There is no requirement that there be a service on your attorney. The only requirement that the code provides is that it be posted on your property or properly delivered to you. The code officer doesn't know who has what attorney for what purpose.
Right, but the court knows that I'm representing.
This is not the court case. This is a special magistrate proceeding that is not subject to the same requirements of a lawsuit. So,
The only response I would have is that I would have to consult with my former attorney and see if there was any way that we could dispute that.
yeah, it doesn't matter whether your attorney received it or not. The issue is whether you received it. You may have turned it over to your attorney, and your attorney may have chosen not to act on it, but that's not the city's problem. That's your problem with your attorney.
Yeah, that's why I'm saying I need to consult with him, because every hearing that had been scheduled, to my knowledge, has been, and I'll say it again, has been extended or continued or canceled based on the letter from Andrew
Right.
Dixon. So
Can you just summarize for the record, what does that hearing video that you have in front of you, what does that reflect? Can you summarize what happened at that hearing?
So I wasn't there present, but depicting what happened on the video, Officer Sanders went before Special Magistrate Cazot, and she presented that proper service was posted at the property and that it was sent out certified. And she also went ahead and got adjudication, a guilty adjudication for the advertisement, which on the video she states that to that day was still listed. It was still up and
What was the
posted.
amount of the fine imposed?
and when he says certified, what does he mean? Certified mailed to where?
Whatever the code requires with respect to service of process, that's,
Found guilty by a special magistrate, must abate by July 31st, 2018 at a $100 cost. Assessment, fine set, $300. It says
Okay.
here, mailed certified NTA 3512, mailed certified NTA 2910, mailed certified NTA 3897, mailed certified NTA 9399.
what does that mean?
Those
Yeah.
are the different
does that mean?
mailings that were done. Not only were they mailed certified, but they was also posted on the property per the video.
And that's shown on the video.
Correct.
Do you want to do you want to have the video as an exhibit to these proceedings? Do you think that's enough?
I think that's
No,
enough.
It's enough, Judge.
Okay.
We've met our burden that
We're
he's
not
been
questioning
Okay,
convicted
well,
of
service.
it is your burden of proof to show a prior conviction, and that's why I made you do what you
Yes.
had to do. So any further response from the property owner before we move on to the next matter?
No.
And just on the, just let's stay focused. All right, so based on the testimony at length of the city code enforcement officers, the documents that I reviewed, advertisements and records, I find that this is a repeat violation of section
5-30D.
what was this?
5-30D.
Right, the illegal advertising. And being that it is a repeat violation, I am going to impose a fine of $2,500 based on the discretion that I have as magistrate to not exceed $5,000. I feel like the property owner understands the seriousness of this violation, and it is subject to the property owner notifying any and all platforms, brokers, advertisers, and anyone else that has any connection with this property or could have a connection with this property, that this property cannot be,
Well,
I'm not done with my statement, that this property may not be used in violation of the city code section. Madam Attorney, can you state the section for the record?
5-30D.
Right. So that is my ruling with respect to the advertising issue. The property owner is encouraged very strongly to take whatever measures are necessary to prevent any more advertisements, regardless of the source, regardless of how it gets there. And should there be any further violations of this particular code provision with respect to this property, that next time the violation amount, the fine amount, will be significantly larger. So that's my ruling on this case. You wanted to say something for the record?
yeah, I wanted to say for the record, well, I think I've already stated that it would be true if I was lawfully permitted to use the house, that I would also be permitted to advertise it. Is that a fair statement?
Judge, I'm gonna object to that. We've already, Your Honor has already decided.
I have
Not
no
This
discretion to, to rule that at any time you had the authority to engage in these activities. I'm bound by the opinion of the city attorney and the facts and the law as I read them. So, you're asking me for a hypothetical that
Right,
I
right,
cannot,
right,
I
right.
cannot really respond to because you're not operating a lawful use.
Well, we're not in that, but that would be
But,
that would be your opinion.
That,
Yeah,
well,
yeah.
yeah, and that's, and ultimately, the court will have to make
Right.
that final decision as to whether or not you were a lawful use or
Right.
not.
And if I was permitted the use, don't I have a First Amendment right to tell others about it?
I'm not allowed to give opinions on constitutional law, so I cannot opine on what First Amendment rights you may or may not have.
Okay.
It is clear, however, as an aside, that if you are advertising an illegal use, and there are cases dealing with prostitution, for example, if you advertise for prostitution, that is an illegal advertisement which will not be
Of course.
protected by your First Amendment
Of course.
rights. So it depends on what you're advertising.
Well, vacation rentals, yeah.
Right, and
Yeah,
the
yeah.
city has deemed your particular use to be illegal. So because it is an illegal use, you cannot advertise it as a legal use. And that's why I'm imposing the fine. And you have a court reporter, and you can certainly ask a judge to reverse this.
Mm-hmm.
And
I think it would be fair to say that during the time that Andrew Dixon licensed me, and it was not appealed for those 7 months, because there's a 7-month gap between when Andrew Dixon licensed me and when Mr.
Judge, objection. Once again, this is
yeah, we're rehashing.
irrelevant.
We're
So,
rehashing, but I will.
But if
so-
I advertised it during that time, it would not be illegal.
No,
Objection.
well,
once
that-
Based
again.
on the fact that I was given wrong information
Okay.
by
You-
a city official.
You have legal rights that you can enforce in circuit court. There are concepts in law, equitable estoppel, for example, where you might prevail. But I have ruled that opinion by Mr. Dixon was ultra-virus and without authority. He acted without authority, and for the proposition, I will cite you to the case of Corona Properties of Florida versus Monroe County, which is a 3rd DCA case, 485 South 2nd, 1314, with similar facts, where a planning director issued a vesting letter without authority, and the court ultimately ruled that legal opinion on vesting was illegal. I also will cite you to a more recent case, Neapolitan Enterprises versus City of Naples, where the planning director issued orders regarding parking requirements, waived some parking requirements, and then the court found that those actions by the planning director were illegal and set aside and void as ultra-virus. So even if Mr. Dixon said that you could engage in this activity, I find that his actions in this case were ultra-virus, illegal, void, and subsequently reversed by the city attorney, whose opinion is the one that really counts. And his opinion was that you were engaging in illegal rentals. I've said that already a couple of times. I'm not going to repeat it. If you feel like you can challenge those opinions, then pursue your deck action and have a judge rule. But that's my ruling.
And judges per day, the 2,500?
No, I'm going to rule that
You found him in
there has been an adjudication on what's before me, and it's $2,500, And then any further violations and especially if he does not act consistent with my instructions, which is to try to do everything he can to eliminate himself from these platforms. I'm saying that the next time this issue comes before me, if he hasn't done that, then I will definitely entertain a much higher fine than the one that I'm imposing today. So that's what we're doing today on that violation. It's not a per day violation because I don't know what he's gonna be doing next week or next month or next year, and I don't know whether he's doing it or somebody else is doing it. I need to see each violation, and each violation will stand on its own facts. That's why I can't do I can't do it per day, because I don't know what else is out there.
So then this is just a one-time fee for this occurrence?
For all the prior occurrences that were before me today,
In regards to advertising.
in regards to advertising. If there's more advertising, if tomorrow he advertises a short-term rental in violation of the statute, the code, you bring it back to me in a month, and then we'll deal with that one separately. At that time, it will be a higher fine.
And obviously, my listing on the MLS to sell my house doesn't apply to this. Okay.
Absolutely, you have
Okay.
every right to list your house on
Okay.
the MLS or any other service that you wish.
And Judge, just for the record, that's over the city's objection. We would ask for an abatement date so that all of this stuff is down and it doesn't continue to happen. And I understand your Honor's logic in terms of if someone else is doing these things, although there's no evidence or proof of that today, that's something that Mr. Galinsky would have to bring up before this court with actual proof and evidence.
Okay, yes. The problem is that your
You don't have proof either?
code, don't interrupt,
sorry.
please. Your code, unlike others, and it may be something that you may want to work on, does not say that the advertising itself is prima facie evidence of a violation. If it did, then we would be in a different in a different case. But I would say to you that because the burden of proof is on you, it's a little bit more difficult to sustain a conviction unless you change your code to say that the advertising appearing on whatever platform is prima facie evidence of a violation, which your code does not say.
Judge, our code is clear in terms of any advertisement, which is inclusive.
But how do we know it's him?
We know it's him because I passed up, and I can pass it up
No,
again.
we've been through that.
Right.
We know that it's him.
Yes.
But I'm saying going forward, if there is a case where you find something on YouTube with his house on it, if you don't know that he's the one that placed it, and we can't prove that he's the one that placed it, then you cannot charge or convict on that violation. If, on the other hand, it was prima facie evidence that he did it, it at least would get it to me to adjudicate in your favor in the absence of evidence to the contrary.
Okay, Judge.
I mean, this is getting into the weeds,
Yeah,
but I'm,
because-
you know, I'm very familiar with this issue, and I don't want anybody to say that his due process rights were violated because we charged him and convicted him on something he didn't do. And
But we're only charging him, and we've only charged him and have convicted him today regarding this advertisement in
Yes.
particular.
which he has
So-
conceded to, by the way.
Correct.
He has
Throughout this-
conceded to, because
throughout this whole
he
process.
thought he could do it legally.
But all we're asking for is that, just like any other case, is that the fine runs until all of this stuff is done, and give him an abatement date like every other homeowner, 30 days, 60 days, whatever is proper, for all of those things to be taken down. He can get a certified letter from any other company or Airbnb, whatever is out there, stating that his stuff isn't going to be up there. And if it does come back up before this court where there is another advertisement, it's the city's burden to
Okay,
prove
so
that it
here's,
was him.
I will say this. I will set another hearing. You can call it an abatement date. You can call it whatever you want to call it. I would like to be sure that you have done everything within your power to take down any and all illegal advertising that's out there, and that you've communicated to everybody that you're not in this business anymore because it's illegal. At the next hearing, if I'm convinced that you have done that in good faith and will continue to act in good faith, I may or may not reconsider the fine that I'm imposing. I may increase it, I may decrease it, but for now, the fine is $2,500.
Per day.
No, it's
Until
not
you're-
per day.
So you're only ordering, I just want to be clear,
I-
you're only ordering one time 2,500.
Yes,
You're gonna reset it for an abatement date in, let's say,
Yes.
30 days.
30 days,
For him to
and then
do-
that will give you an opportunity to bring Mr. Woland back, and he can, I know he's a
Judge.
witness.
It has nothing to do, you have already ruled that
Uh,
that matter has nothing to do with
That,
this
I'm not
case.
gonna get into that. I'm not gonna get into the legal issue. That's up to the court. But since we're not talking court and we're not talking what the planning director did or didn't do, or the city attorney did or didn't do, and Mr. Woland will not be a witness as to that, he can certainly represent you on the violation themselves.
He could be a witness to.
No, he's not, he's gonna be your attorney
Oh,
on the.
he's not
on-
my
on-
attorney anymore.
Well, whoever your attorney, you will have an opportunity to have an attorney with you.
He can't come back as a witness to
There-
to discuss some of the rulings that
No,
you've
because,
done?
no, because that's not something that is the subject of fact testimony from any witness. Those are matters of law, and I've already determined those are matters of law, and I've ruled on that. But you certainly have a right to have an attorney present when we talk about
Sure.
the fines and the violations that were imposed.
What I'm concerned about is the alleged hearing that I missed. That's what I'm talking about, of the advertising that I missed.
Okay, so if
I mean,
you
could
would.
Frank Wallen testify that I don't know, whatever.
I don't, if you have evidence that didn't happen,
Then I can bring it in.
bring it in,
Okay.
and as a matter of fact, one of the things that you might want to discuss with the city attorney,
Mm-hmm.
if you can, and Madam City Attorney, if I could have your moment,
Yes, Judge.
if the property owner is able to convince you that he did not get proper service regarding that prior violation that we saw on the video,
Then he-
then will you dismiss the case?
No, Judge, absolutely not. He's already outside of the purview, since this happened a year ago, pretty much, on June 6th, 2018, he's already outside of the purview.
But he
of
didn't know
even-
about it. He claims he didn't know about it.
Judge, he claims that he didn't know about it today because it's affecting him on this
Okay.
case. But he's outside of the appeal time that he had to go ahead and appeal
Yeah,
that.
but jurisdiction can be raised at any time.
There's no way, Your Honor, that Judge Cazot is going to find him in violation and adjudicate him without believing that there was proper service. We have read to you certified mail 3 times that was sent to him and posted, which is our obligation.
All right,
that
so
was done.
here's what I'm gonna do.
So we're not dismissing the
okay.
case.
No, I was just asking a hypothetical. I mean, it's happened,
What about if someone
No, wait.
posted it on, I'm sorry, what if someone posted it on the door?
Okay.
Just we're
And
not here
somebody
for
took it off the
hypotheticals.
door?
We're
Look,
not here for
if there-
hypotheticals, and
if-
I don't know why this
I
keeps-
never got notice of that.
if there is no notice, the remedy is go to circuit court. That's the remedy.
So
You didn't
so-
get notice, lack of jurisdiction, lack of due process, fight it in circuit court. Don't
And
bring
that's
it
something
back.
that he needs to do, but we're not here for that
Okay.
today.
And also regarding her comments about, I know it's a one-time fee. She's saying she wants to give me time to take them down. They're already down. There is no advertising going on by me.
showed you
And there's
Okay.
nothing that you can show me to prove that I'm advertising, because
Well,
I'm not.
I need proof
And-
that you've contacted all of these people to
All of-
confirm,
Peop-
that,
What do you
under
mean, all these people? Who am I gonna contact?
all the platforms
It's not on there.
that do short-term rentals.
This is the first Wednesday.
I mean, it's so difficult to get them to do anything. I mean, I could write a certified letter to each, I mean, Airbnb won't even talk to me as to
All
why
right,
they pulled my listing
talk to
down.
the code officer and see what satisfies the code officer so that this doesn't repeat itself going forward. And we'll have a meeting in a month to see where we're at, but the
Okay.
fine
So-
stands.
So if they find my house on Airbnb or another one, I want them to be able to tell me that that's my listing. That's not my listing. I don't know how you prove that. It's confidential information. That is not my listing. When I had my listing up, I had a
All right.
listing number with my
You
picture.
come here and you tell me under oath that you had nothing to do with that listing,
Uh-huh.
and I will give it whatever weight I feel appropriate.
I will do whatever
Okay?
I can to make it confirm that I'm not
Yeah,
in those
but I need
websites.
to hear each case separately. I can't rule indefinitely as to whether you did it or didn't do it or who did it. I just can't say per day because I don't know what the next day and the day after that will be. I need to
And
hear
Judge,
each case
since you're
separately.
very familiar with this case right now, I'd ask that it be before Your Honor, the next time that Your Honor is present.
Bring it, think I'm here June 5. If June 5 works, I'm here. Yeah,
Okay.
I spent quite a bit of time on researching every aspect of this case. And I don't want, I don't want to blame you for somebody else doing stuff to you, but understand that we need some assurances that this is not going to continue to happen. Certainly, the
For me.
For you.
I mean, I have argued with Johnny, who has, I could give you the listings
All
that he
right.
had. If I could scream up and down, I call Airbnb, I've had them pull the listing off, and about 2 months later, it popped back up. I didn't know. I had another client call me up and say, hey, your house is on Airbnb with another name and another listing
Once
number.
the word gets out that the city is going to fine you, and you're gonna see less of this going on. So let's move on to the next case, which is the actual
Rental.
rental. And I read the report. I'd like to have the city tell me what happened, when it happened, who was there, what was said to you. Tell me why you cited the property owner for illegal rental.
Your Honor, I have a sworn statement that I wrote. I'd like to enter into evidence so you could read.
Is it very long?
No, it's a short, brief.
Then you read it.
Okay.
Because the affidavit may or may not be evidence.
Okay, not a problem. On March 30th, 2019, at 9:35 a.m., I was dispatched out to 121 Road in reference to a short-term rental email complaint that was submitted to Code Manager Cordo. Upon arrival at 10:05 a.m., I made contact with the person who was staying at the property. When he opened the door, I observed several people sleeping on the couch, several beer/water bottles laying around, and empty food boxes. When I asked if he was the property owner, he advised he was not the property owner, that he was only staying there for the weekend with a couple of friends and they were having a party. When asked if he had the owner's permission to stay at the property, he advised that he rented through Airbnb. When asked for the booking confirmation, the person staying at the property showed me an email from Airbnb confirming his reservation. A picture was taken of the confirmation for evidence, which can be submitted into evidence.
Does it have the listing number on it? When you said you took a picture of it.
It's there.
That's
I could-
Johnny.
we could show it to you.
Who's Johnny?
Johnny is from Kansas City. He's he owns about, or manages about, he claims like 60 homes. I don't know how many he's actually got. So Johnny would call me up and say, hey, I got a client for you. I'd be like, oh, great. So X amount of people. He didn't tell me he had a client for me that came from Airbnb. He just told me I had a client for you. So he came to my house before. He wanted to manage my property. I told him I don't want anybody to manage my property. I'm doing it myself. So if he called me up and sent me a client, and that client paid Airbnb, it wasn't my listing. I didn't get no money
Your
from
Honor.
Airbnb. I haven't gotten money from Airbnb since January.
All right, at this point, whether it's Airbnb or the Man in the Moon,
Then I'm not
if you've got
advertising.
people, no, but
Then
this
I'm
is
not
not, we're no
advertising.
longer talking about advertising.
Oh,
Now you're
okay.
using your property
sorry, okay.
for an illegal purpose, and regardless of how those people got there,
Okay.
you're in violation of the law.
Okay,
Now, you must have entered into some kind of an agreement with somebody. You wouldn't just allow people to spend a weekend at your house, sleeping in the couch and using your property without some kind of a lease, right?
Correct.
And you have a copy of the lease?
Yes, we do.
Judge, I have a
Well-
copy of the sworn statement. I have a copy of the, in addition to that, of the complaint that was, that Mr. Perez referred to, and also a copy of the picture of the phone that was taken by, Mr. Perez in regards to the people who were staying at Mr. Galinsky's property.
Okay. Is the lease included as part of the
His
exhibits? The lease with the,
The confirmation, the
confirmation,
booking
yes, it's up
confirmation.
there, it's on the phone.
yeah, but there's gotta be some kind of a written agreement between somebody and the people that are occupying
It's on the
the
phone.
property.
Yes, it's a confirmation with the dates.
The means of the rental itself aren't in question here. What's in question here is the rental itself.
Yes, that's what we're talking
Yes.
about.
Yeah.
Yes, and the rental was
I-
for how many days?
but I
Wait,
did-
wait, you'll have your turn. How many days?
On the email, on the photograph, 1 second.
It's in the photograph with the phone, Judge.
It
that you-
states March 21st, reservation reminder for March 29th, and they were there for the weekend. So the weekend of March 29th.
Okay, and you're not allowed under the code to rent to anyone for a weekend, right?
Correct.
Were the people that were staying there related to one another?
No, he said they were friends. The person who opened the door and answered the door to me advised that he was there with his friends at the property.
How many people were there?
More than 10.
Is
I
there-
don't have the head
is-
count.
Is there an occupancy limit in the city? How many people can stay in a single-family home?
I'm not aware, and I don't think that's relevant.
Yeah,
Well,
it's-
just wondering, how about unrelated families staying in the same place?
I would have to do research with the code.
Just asking, just curious.
No problem.
Are you saying that the acts were illegal because it was a rental, or because they were engaging in a business, or because they were doing other things that they were not supposed to be doing, or
It's a
all of the
short-term
above?
rental.
Just a short-term rental itself, which is the violation in question today.
Okay. So if there was something else going on, because I think you mentioned something about alcoholic beverages.
I just documented that as what I saw, a visualization of what I did pictured that day.
Okay, and this was told to you specifically by the people that were,
He was
staying
there,
there.
Judge.
I
Yeah.
was there. I was present
Yeah.
at the time when
right? Yeah, that's what I meant.
yes.
Okay. Any comment from the property owner?
I did not contract with those people directly.
Did you get any compensation from anyone as a result of this rental?
Yes,
You did?
No.
Okay,
from the agent.
from the agent?
referred me
Okay,
to
you didn't,
clients.
and these were not people that you knew personally? Right, correct? They were
Correct.
not having a birthday party or a reunion or anything like that?
Correct.
So, do you agree that this falls
Yeah, I'm
within the
not
short-term
contesting,
rental?
I'm not contesting the short-term rental for that date, no.
Okay,
No.
So we seek an
I-
adjudication and a
if I
fine
can-
of $15,000 for the occurrence.
And at the last time this happened, Judge, and it came before this court, the 15,000 was charged to Mr. Galinsky for this short-term rental.
Again, I was never convicted of short-term renting. This is the first time, I'm telling you, we have never been to a hearing. I have never been convicted. A lot of these fines disappeared when Andrew Dixon licensed me. And as far as my attorney advised me, is that we believe, based on your criteria and your package, that you meet criteria for the grandfathering law, and that you need to continue doing what you're doing, and if you cannot get remedy here in the city, we'll take it to the
Okay.
state court. So
I-
that's why I
yes.
kept going.
I can tell you who was present. His previous attorney, Mr. Wolin, was present. The code enforcement officer.
present when, for what?
For when he got fined the $15,000 the last time that this happened, because this has happened for so long.
$15,000
Yes,
for an
for-
illegal rental?
Correct. That's the max. It's a one-time
Is that the same
occurrence.
case that was,
No.
in the-
No, no,
this
no,
is
no,
a different
because-
case?
Yeah, we're talking about the rental specifically.
Okay.
I'm letting Your Honor know that the last time that he rented the property out, because he continues to rent the property out, the magistrate was Judge Benjamin, and he did impose a $15,000 fine. The code enforcement officer was Vanessa Willis, and the person who appeared for him was Mr. Wolin. So let's not even get into the topic of service.
What was the date of that violation? Or
can-
year?
October 9th, 2018. And it is a fine lease case.
October 9th?
2018 is when the violation occurred, or when it was opened.
And when was it adjudicated?
Give me 1 second and I'll tell you right now.
So we are asking for the max, and anything less than what was previously imposed.
Well,
It's-
here's, I hear you, but here's, as I read the code, $15,000 is for an irreparable or irreversible violation.
Correct, and he found that it was.
How so?
Because you can't take away the rental. It already happened.
It happened
It's not
already.
fixable.
That was his reasoning.
Yes.
Okay.
And it was for February 20th, 2019 at 10 a.m.
February 20th,
2019 at 10 a.m. And the fine imposed was $15,000 plus $100 for cost.
for this type of violation.
Correct.
Were you present?
No, it was Mr. Wolin on his behalf.
Mr. Wolin?
Correct.
Has that been appealed to any court?
Not that I'm aware of.
No, it's just a filing case.
And it's still pending? It hasn't been paid?
It has not been paid. Correct.
Has there been a lien on the property?
I'm not sure what the process would be. That's more on the administrative side.
Okay. Explain to me, I'm not quite there yet, but tell me how a violation of a short-term rental ordinance where people just show up and spend the weekend there and then they leave without causing any problem to the community, without, hurting anybody, how does that become irreparable and irreversible?
Well, we have several police reports stating that there has been occurrences where police has been dispatched out, excessive parties, drugs, even alcohol with minors. There's a police report that came across that was sent over on Monday, I believe it was, that we could enter into evidence. Code Officer Willis is here. She could also give her testimony.
Yeah, I don't know that I necessarily agree that a one-time violation of the short-term rental ordinance is irreversible or irreparable.
It is, Your Honor, because it already happened. There's no taking it back. In addition to that, Judge Benjamin considers, obviously, all of the prior incidents, like Mr. Perez was trying to explain, that's happened on this property, that we definitely have proof of, and I can pass up to Your Honor, in terms of people ending up in the hospital, in terms of
Yeah,
the
but we're here
continuousness
on
of-
this violation, not what
Correct.
happened in the past.
But on this violation, there's nothing he can do to take away that rental. And whether something happened on that property that specific date or not is irrelevant to the fact that it was already rented, it happened, it occurred, and
Okay,
he can't take it
so
back.
here's what is irreparable or irreversible. Somebody gets killed. City property is destroyed. Vandalism.
How can you take, no, not vandalism, because you can go ahead and, clean it up, paint it over. How can you take back the fact that he's already rented that property that weekend to those folks?
That's true for just about any other violation in the city where, somebody violates and then.
Not only that, but it has come to where it is a sufficient complaint from the homeowners association where it's a nuisance to the neighbors
Well,
around.
that's when
And
we
for
get
this-
into the repeat violations. That's the test that you would use is if it's been done before.
Right.
But for this specific case, you also have an email there from a homeowner who has sent it to various,
City officials.
Yeah, city officials, the code enforcement manager regarding what was happening on that property. She even references the $15,000 that was previously fined on
Adjudicated.
that property, if Your Honor reads to the very end.
We have neighbors that are being blocked in from their properties or blocked out from the properties because of the access parking from other vehicles. The list goes on and on of
I'm sorry, what am I
nuisances.
supposed to be reading?
The email, Judge,
Oh, I
that's
don't-
attached to the actual advertisement.
I don't have it.
You should have 3 things up there. Take it back.
I believe I gave them back to you.
Okay.
Oh, I do have it. Here it is. That's just the email. And that's just from one of the neighbors. There's been many more neighbors who have complained regarding
Oh,
this
I'm
matter.
sure that this is a tremendous imposition and nuisance and, on the neighbors. Believe me, I understand that. I'm just dealing with a very narrow interpretation of what is irreparable and irreversible.
What's
Eh,
irreparable is the pain and suffering that the neighbors are having in that community because of the
Mhm.
occurrence.
Mm-hmm.
What's irreversible is the fact that you can't take it back. It already happened. There's nothing you can do to undo that rental, unlike other things. And in addition to that, the city doesn't seek that $15,000 fine just for any case, as Your Honor has seen. Working here for
Couple months.
as long as you have been here, we don't lightly seek that fine unless it's warranted, Judge. And
Okay.
in this case, well, in the last case, it was warranted because Judge Benjamin found, the $15,000 fine, and in this case, it's warranted. There's no way of taking it
What
back.
are
That
the, are there any similarities in the facts between the two cases, between the prior case where Special Magistrate Benjamin ruled and this case? Was that case more egregious or not?
It was
Usually it
same
has-
circumstances, and Officer Willis was actually here to explain that. I'm not
the-
sure if
the-
you would want to hear her testimony in regards to that case itself.
But at the end of the day, the circumstances don't really relate, because if that's the case, we can go into all of the life-threatening situations that have previously happened while this property has been rented. What the code specifically states is and I'm reading as to 5-1610, is the rental part of it. And that's where we're saying that it's irreparable and irreversible, and we're seeking the $15,000 fine. There is no subsection or any interpretation regarding what happened this time versus what happened last time, which is why I'm not gonna get into all of the previous bad things that have happened at this property. If that
Yes.
was,
Can I respond?
Yeah.
Okay, the
Yes, sir.
violation we're talking,
One second, your court reporter has a question.
I'm sorry, I just need 2 minutes to use the restroom.
Go.
Sorry.
Yeah, we need a record, so. Are we ready to proceed? Are we ready? Yes. Okay. All right. Let's see where we were.
I believe I was just giving the distinction between the code the code specifically talks about the fact that there's a rental. It doesn't matter what surrounds it. It's not a requirement or anything that we have to prove. But if Your Honor does want to hear those kinds of things, of course I can provide the background, but that would not be a requirement.
Well, the code does require that I take into consideration three things
Yeah.
in assessing the amount of the fine, and that is the gravity of the violation, the actions taken by the violator to correct the violation, and any previous violations committed by the violator. So in assessing the proper amount, I'd like to be consistent, and if the facts are essentially similar, and there has already been an adjudication, then I'm inclined to follow that precedent.
Right. So we can talk about, because it's our burden. Do you want to hear from us?
Yes.
Yes. So in terms of the gravity, this has been going on for a while. There's been, I'm not going to get into adjudications because it's going to take a while, but just rentals alone in terms of citing, there's been 16 previous, and I can pass that up to Your Honor, citations. There was the email from one of the neighbors. There's also Mr. Perez's testimony regarding the garbage and the alcohol and stuff that was going on in the area. There was just simply the fact that we were here last time in front of Judge Benjamin, and he got fined $15,000, and he still continued to do this. Is a blatant disrespect to this court. In addition, most recently on May 9th, 2019, there's an incident report, which I will pass up to Your Honor, or I could read myself, by the North Miami Police Department.
As long as you make it part of the record.
And I also have, because we're talking about previous and egregious violations, one from 5/13/2016 that I'm passing up regarding this property. And that, I'll let Your Honor read as well, but involved 500 juveniles with alcoholic beverages being consumed in the house. 2 were so intoxicated that they needed medical attention. There was drugs
What's the date of that?
on the property. That was 5/13/2016. That's also an incident report from the North Miami Police Station. And then there was also Mr. Galinsky's own personal issues in this property on April 25th, 2018, where it's a criminal violation of matter. And I'll pass up the arrest form, which I did a request for. And that's pretty egregious as well. And I'll pass it up for Your Honor to read.
That's not a vacation rental. That's me using my own house.
Well, we're talking about the gravity. We're talking about the actions taken, which have been none.
And on-
Since, excuse me, sir, I'm still speaking.
You'll have your chance.
We're talking about the gravity, the actions taken, which have been none. We know that by the fact that he was fined the $15,000, and still on, oh, I didn't pass it up, Judge, May, okay, on May, you gave them the May 9th one? Okay, and still on May 9th, not even a month ago, it was rented by Mr. Galinsky himself. And the people had to leave the premises for $2,500 that they paid Mr. Galinsky. So if we're talking about previous, Your Honor has previous. If we're talking about actions taken, there have been none. And if we're talking about gravity, Your Honor has police reports, incident reports that was conducted on this property.
You know how many police calls have taken place there in the last couple of years?
I have a report in terms of, and I it's the same report from the advertisement that Your Honor can see regarding the rentals.
About how many?
There's been 16 for the rentals. In terms of police reports, give me a second and I can look for that specifically. I don't know if that would be indicated on here. I know specifically of the 3 that I passed up to Your Honor. This is this would say code. I don't want to misstate in terms of how many total police incidents. I could gather that information for Your Honor, but in terms of violations and code, what I have here on my document is all of the issues, the accumulation of waste, the nuisance, the excessive noise, again, accumulation of waste. These are all things that are happening after he rents his properties that are affecting the homeowners.
Well, I'm gonna disregard any reports or incidents that do not relate specifically to the issue of short-term rentals. So if any other type of activity was going on, whether they be drugs or whatever, I don't think those are relevant. But
Judge, are you relating to the incident report with the
Yes.
500 juveniles?
No, I'm relating to an incident report that talks about activities with a minor, trafficking.
Oh, okay.
Okay?
Okay,
That-
but you are considering the actual incident report with
Here's
the
here's the
juveniles who
page.
ended up in the hospital?
Yes,
Okay, and the recent one on May 9th?
yes.
Okay.
Any, those matters that relate to the activities engaged by the property owner with regard to short-term rentals.
Okay,
If there are noise violations, graffiti, debris, litter, any of those issues that usually are associated with short-term rentals, illegal parking, noise, things like that, I'm not taking those into consideration, although I know that that is primarily the reason why these ordinances get enacted, is to prevent that. So I'll ask the property owner, please feel free to respond to anything that the city attorney or the city code officer have stated with respect to the issue of the amount of the fine to be imposed by the magistrate.
If I may add, before we hand that over, one of my coworkers just confirmed with police dispatch. In April, there was 5 calls, and in March there were 3 calls, and prior to that, there were several other calls throughout history of that property itself. So those were the calls that came into the police department for that property itself.
Okay.
Thank you.
So, I'm considering imposing the maximum fine of $15,000, which was imposed by the special magistrate, given the gravity of the violation, the actions taken by you to correct the violations, previous violations, and, in general, your disregard of the city's code.
My first question is, the original violation that my attorney attended was for what dates?
wait, what?
I'm,
Judge, we're
From
here.
the last magistrate, because you're saying that this is a repeat offense, and you're saying that I was fined $15,000 for short-term renting when?
Judge, we.
February 20th
February 20th, yes.
2018?
2019.
this year.
Of this year?
Yes.
And during that rental, were the police called? Was there a complaint? Is that why the police came out, or they just randomly came out there to?
I don't know, and
Well, I'm
I-
asking them.
Well, we're not here to hear that case today. We're
No,
here to
no,
hear the
but- no,
case
but
that's before
I-
us. You're asking us a question, and I'm responding, so if you'd like me
You're
to
not,
respond,
you're
then
not
give
on
me a
topic,
second.
but you're not on
Then
topic.
give me a second. You're not on topic. Okay, that case is not before this court today. The case is before this court is the one that we're talking about, the short-term rental for Saturday, March 30th, 2019. As it relates to that case, he was represented by an attorney, Mr. Wolin, who came before the court. It was adjudicated by the magistrate. If he wants to appeal that case, he can go back and get an attorney or do it himself and appeal it before a circuit court, but that is not something that we need to be
Yeah,
discussing
we're not
today.
gonna rehash that particular case, although I am taking judicial notice of the fact that you were fined $15,000 back in February, and here we are in May,
Mm-hmm.
and you're still doing it.
Okay, but my question is, they're saying, and I forgot the term that you used, to make it more severe. And what I'd like to know is, on May, whatever 30th, was there a complaint? Was there a complaint of noise? Was there a complaint of anything related to, I mean, why did code enforcement go and check that day?
He's got a right to cross-examine you, so
Yeah.
you can go ahead and answer.
As stated in my statement, originally it was an email complaint that was sent to our manager, and in return, she forwarded that complaint to me, and that's why I responded to that property.
Those clients were Asian. They didn't have a car. They were never outside. What was the complaint about? What did they do?
Again, loud music, the trash. There was actually a violation that was opened up by Officer Karen Jean Lewis for the trash that was placed out early for that specific day, actually.
So if there's trash outside, you're gonna go knock on the door.
I knocked on the door in efforts to make contact with the property owner, at which time I found out that they were renting.
Okay, so the point that I'm trying to make is, if this was a repeat offense, like they're stating, and it was egregious, I don't know what the term that she used, it was something to make it, and you were questioning it, was something going on there above and beyond the normal of somebody just renting? And I know, because I want to make sure that the cases that they're bringing up about prior incidences is not what we're here about. We're here about, did I repeat, and did I do it again? And I just want to make it clear that those two incidences that they're documenting as short-term rental, there was no police call, there was no crazy things going on. I mean, garbage being left outside is not something that I would think anybody would consider as severe. So I just want to make sure when you
Well-
rule
talking
that
about
you're
Yeah,
taking that into consideration.
I read his affidavit. I also heard what he said. And just I don't want to repeat it, but there were allegations of people unrelated sleeping on couches, beer cans.
In the house.
Well,
Yeah.
why don't you answer his question as to what was egregious about
Yeah,
this?
exactly.
As previously stated, what I observed was people inside the house sleeping on the couch, beer cans everywhere, trash and debris, that sort of things inside the property, yes.
Judge, I also want you to take notice of the fact that Mr. Gilinski has said in open court more than, I want to say 20 times, that he does rent this property out. So by his own admission, he's in violation of 5-1610.
Yeah, he's conceded that we're
So-
now we're now beyond that, and
Right,
the
and
the
you
issue is it irreparable and
Exactly.
irreversible?
That's,
you
those are the
asked-
terms I was
and-
trying to get to, Matt.
And you've asked in terms of the gravity, the actions taken in previous incidents. So you have read the incident reports. I don't know if Mr. Gilinski's not paying attention or listening, or if he needs to see it again. But there
Those-
have been incident reports where people have ended up in the hospital.
We're not here for those reports.
So
We're here
we
for
are, because
May
one of the
30.
things that you have to take into consideration is previous things that have happened at this property because of rentals,
Mm-hmm.
and that's one of them. And that is egregious. 500 juveniles with drugs and alcohol, where 2 end up in the hospital. That's pretty egregious to me. So that's why it was brought up, because we can bring it up, because it's a previous encounter that happened at this property.
Okay.
Well, that was back in 2016. I was never fined. I was never told that I was doing anything wrong in 2016. I have no violations of that, and I don't know if that's true. That's what the officer wrote. Nobody ever told me any type of bad thing like that ever happened. But the case we're here today is for a vacation rental violation. I think they said March 30th, when the music festival is in town. So, if you go to any house, there's going to be people there drinking beer. That doesn't mean that there's anything, corrupt or bad going on just because they're sleeping on a couch. I don't know how his explanation of coming to the house and seeing what he saw is irreparable. And I would like to also know if, since they're saying this is a repeat violation, the first one, was that irreparable? What happened during that rental that made it irreparable? I don't even know what happened on that.
I
even
don't
I had-
know,
yeah.
I wasn't there and I didn't see it, but I have to
Is
be
there- is there a
consistent.
report?
Yeah, but I've got to be consistent because we can't have special magistrates. We have 3 special magistrates all over the place on what the appropriate fine or penalty should be. We ought to be consistent so that we're predictable and people know what the consequences are for illegal conduct. To me, the violation is grave. That's number 1. Number 2, you didn't take any action whatsoever to stop once you were fined $15,000 by the prior magistrate. You knew that if you were cited again, you might very well have to pay a $15,000 fine. And number 3, any previous violations, we've already noted that there have been several. So I think that the evidence is there to sustain not only what my fine amount will be, but also what the prior magistrate found with respect to the matter that was before him. So I will
Can I
fine
say-
you $15,000 as an irreparable and irreversible violation. It meets the criteria. I have seen the evidence. I have seen the reports and what the and what the code officer stated in his report. I think that that you need to do a lot more than just wait to see what happens in circuit court. I think you need to, grab this issue by the horns and say, I'm not gonna do this anymore because I'm gonna be getting fined.
Where
And
have-
these
where have
fines
I-
will become a lien on your property, and if you wanna sell it,
That was my next question. I don't have anything from the city saying I've been fined. I don't have there's no lien, there's no, I have nothing saying I was fined. Now, they're saying there was a court case with my attorney. I would like to speak to him because as far as he told me, everything is on hold right now.
okay. I don't know how the city code compliance handles liens and notices and what have you. I know that I have signed quite a number of liens in my short time here, so I'm sure that in due course, these violations will turn into a property lien against your property, and you're gonna have to satisfy those liens when and if you do sell your property. So I'd be mindful of that.
Well, I think also, and it's too late because you've already ruled, I think you should also take into consideration that my efforts and my initiative with my house being up for sale needs to be taken into consideration. I also have a client at the house right now who is staying over 3 months, so I'm in compliance.
Good.
And I'm stopping the short-term renting. I've already stopped the advertising, and I, hope that you take that into consideration when, and, if, I may sell the house before the client finishes his vacation, and that is something I'll work out with the client. If I can get the seller who has already verbally said that he's gonna buy the house, which he's down the street, so he's already has a house
All right.
there. So I think, if, the court would take into consideration those things to show that I'm making an effort to comply, and obviously by me not being the owner of the property, that solves the problem, and that's in the near future. So any type of reoccurring things really are.
You can always mitigate the fines with the city manager.
Okay.
I have suggested a progress report on the advertisement issue.
Right.
And that's why I have not imposed a daily fine, because
Okay.
I want to see what efforts you are making to stop those advertisements. And
Wait,
so,
you mean the advertisements done by other people? Because I have stopped all mine.
whatever you need to do to stop them to the extent that you have control, then you need to exercise that control to the best of your ability so that we don't see any more advertising.
Okay.
But beyond that, the next time we hear another violation, if we have, people going in there on the weekend, Memorial Weekend coming in and, you know, and we're gonna have 5 or 6 different families staying
No,
there.
the people that are there now are gonna go through that.
Yeah, well, that'll be the
because-
next people.
No, the people that are there now are there for 3 months, over 3 months. So they're
Then,
not-
then they're in
There will
compliance.
be no issue with
And,
Memorial
and,
Day, anyone else
and
coming.
you should have a lease
one.
indicating that they are
do.
there for 3 months
do.
and have that lease ready in the event the city knocks on your door.
It's ready.
Okay. Thank you, sir. See you
You're
next time.
welcome. Alrighty.
Okay.
So we have a hearing date set?
I'm sure that the code compliance officer will bring a progress report back to me whenever, I believe I'm here June 5, so I
So-
could hear it on June 5.
Has that been determined yet or not yet?
Well, I'm available,
Oh,
and
okay.
the city attorney has requested that I be the one to
Okay.
hear it,
Okay.
so I'm more than
Can I-
happy to hear it.
Where can I change my address? Because where they're sending it to, I no longer
You have to
live.
do that with the county property appraisals page.
Okay. That's something online you do?
You have to go to the county property appraisal in downtown and talk to them.
I just can't give you the new address, the code enforcement.
You have to go ahead and do it with the county.
They have to follow whatever the county has on file, that they
I
can't.
mean, if you look at my driver's license, it has the house, the house, the
Well-
vacation rental house.
That's
So
how you properly do it.
why is it not, why is mail not
Legally,
going
you're
there?
obligated to have your correct mailing address as an FYI.
There you go.
Okay, so what's on the driver's license is not the county? It's not the same as the county?
You have to update, every time you move, you have to update where your mailing address is for your properties as well as your driver's license. It goes hand in hand.
So where my driver's license is not going to be
Yeah, let's-
necessarily.
that is-
let's-
that is a
You have
difference.
You have a different address
Listen,
than my driver's license.
we've had enough time
Okay.
on this,
All
so
righty.
go
Thank you.
outside, resolve it.
Okay, thank you. Your Honor.
You're welcome. Let's finish up on whatever other matters we have. Mr. Court Reporter, you're free to go.
The next case on the agenda is item number 13020 Northeast 6 Ave Prestige. John Dorville is the officer. The case number is MHBI 2019-00058. This was previously, fine was set at $250. The abatement date was May 8 of 2019.
Item what?
Item number 1. Now I'm gonna go in order.
Okay. This is Prestige.
13020 Northeast 6 Ave Prestige and Prestige Estate.
City, go ahead.
Good afternoon. Today we'll be hearing the case of, give me one second here, I have the document in front of me.
13020.
Yes, sir. This is MHVIO 2019-00051, correct?
58.
58? Okay. 58.
Repair dumpster.
13020 Northeast 6th Avenue, correct?
Correct.
Okay. Right, so this is a question, this property, the dumpster has been damaged. The property was posted 4/23/19 at 2:58. Proper service was given. I'll show up the pictures if you'd like to see them. The dumpster doors are not are not affixed to the actual physical dumpster. And it's in the rear, this dumpster is actually in the rear of the property. However, the doors are damaged and are not affixed.
Yeah,
and
let me
cannot
see,
close.
let me
Yes,
see the
sir.
pictures. All right, so the dumpster needs to be enclosed.
Fully enclosed, yes, sir.
Okay, all right. Anything else?
No, sir.
Okay. Based on the unrebutted testimony of the city's code compliance officer, the photograph and other evidence presented, that the property has been out of compliance, I find in favor of the city and hereby ratify the fines accrued to date in the amount of $250 and assess costs in favor of the city and authorize the filing of a lien.
The next case on the agenda is item 3 through 11. AGS and Associates, John Dorville is the officer. All of the cases, the fine was set at $250. The abatement date was April 10th of 2019. The case number is MHVIO 2018-00886, 888, 890, 891, 892, 894, 897, 898, and 899.
And all the abatement dates are the same, and the
Correct.
fine is the same?
Correct.
No response from the property owner?
There has been limited contact with the property owner, however, they have not made the necessary changes. I'll go through this very quickly, if we could.
Yeah, tell me about each one individually, and then my ruling will be as to all.
Yes, sir. So let's start off with the service. Service was 4/22/19 at 3:58 for all cases. The initial one, we're talking about MHVIO 2018-00886. This is in reference,
Missing lighting?
no, this is all missing lighting on each unit, please replace. So there's some missing lights. Each one of the units and around the property has missing lighting. So that has yet to be corrected to this date.
When was your last inspection?
The last inspection was the day actually of the posting, 4/22.
Okay.
The next one, you ready?
Yes,
The next-
let's
Next
deal
one
with-
is MHVIO 2018-00888. This one, same service, same date. This one is in reference to please repair leaking AC units. The entire property has really just a bad, it's painted white, but haven't been painted in a while. They have the old school hanging windows with the ACs in them, and they're leaking directly onto the paint and therefore causing mold. You want to see the picture, you can.
This is, but it's caused by the air conditioner?
I mean, it's basically, there's mold directly from the AC unit down the wall where where the AC has the.
I do want to see the pictures.
Absolutely.
Are there people living there?
Absolutely, they are. This property is occupied.
Are they tenants?
They are tenants, yes.
I assume the tenants don't like living with mold conditions.
Probably not.
Oops, sorry, I dropped it.
The next case, if I may, is MHVIO 2018-00890. This was same service, 4/22. And this one is in reference to the, please obtain,
Garbage,
well, this
garbage.
one says obtain fencing permit. Garbage enclosure, yeah, exactly. The garbage enclosure damaged, wood is older, there is some cracking, some wood planks that are not affixed to the actual fixture, it's just really in disrepair.
Next.
Next one is MHVIO 2018-00891. Same service date. Referencing electrical room, there was no access given to the electric room at the time of the posting. Which is a fairly, please make sure the storage inside, but operable light, things of that nature. You have to need, basically, as part of our inspection, we gain access to the electric room, and we make sure that they have a fire extinguisher, obviously, and that there's, and then interior light. I did not gain access to that at that time at the posting.
Next one.
The next one is MHVIO 2018-00892. Same posting date. This is in reference to, they have the old Jollcy windows with several cracked and broken, affixed on various, it's obviously an older building, so the old Jollcy glass pane windows, and they're missing and damaged on most of the actually units. I can provide a photo as well.
Okay.
If I may, the next one?
Yes.
Yes. MHVIO 2018-00894. Same posting date and time. Also referencing, this is the annual inspection at the exterior walls. The previous pictures show the condition of the exterior walls, obviously. Next one is 2018, once again, MHVIO 00897. Same posting date and time. This is referencing the paving on the property. It hasn't been paved, damaged. The parking blocks. I also have a picture of that if you'd like to see it.
It's okay. Don't need it.
Okay.
We have, what?
Two more cases.
Okay.
Yes, sir. MHVIO 2018-00898. Same posting date and time. This is referencing, please provide proof of monthly extermination report. No proof has been provided.
Last but not
The
least.
last one was, this is in reference, this is MHVIO 2018-00899. This is in reference to the mailboxes and the proper numbering and order of the mailboxes, and they basically wrote the mailboxes in a black marker. So it didn't meet the housing standard when they placed the numbers on there. I have been in contact with the property owner. The property was posted. We had conversations about addressing some of these issues. I thought that she would contact me once she had the property posted with the notices, but I got no contact up until this date.
Why do you suppose they're ignoring you? Why are they not?
This particular property was cited by Code Officer Golden. However, we have been in contact. There was initially, when she first cited this property, there seemed to be a transfer of ownership. So it's gone to somebody who's familiar with the older owner, but a complete transfer of ownership. So we put some things on place. And as of the last hearing, there was a conversation with I was in, text conversation with the property owner. She's having some issues in reference to tenants and, the issues. I actually cited this property for not having, the water had gotten turned off at some point in April, I believe. So they've been having some various issues at this property that I guess at this point she hasn't been unable to resolve. But she's in contact with us. She has my phone number. I have her contact information. And this is a reference of trying to get this property on board.
So she's aware that, these fines are going to keep on running.
She is aware, and I'll be working with her in the near future to try to address these things. And obviously, the fines are the penalty for not doing it within a timely manner. But we're attempting to get this property on board and corrected.
Okay. So, as to all of the cases involving AGS and Associates, there's 1, 2, 3,
9 in total.
4, 9.
Yes, sir.
As to all 9 cases involving the property at 14399 Northeast 5th Place, which properties have been previously adjudicated guilty by the magistrate and fine set of $250 as to each separate violation. Based on the unrebutted testimony of the city's code compliance officer, the photographs and other evidence presented, I find that the property has been out of compliance as to each separate violation since the last magistrate imposed the fine and set a compliance date of April 10th. So I find in favor of the city, hereby ratify the fines accrued to date and assess costs in favor of the city and authorize the filing of a lien.
Thank you.
The next item is item number 12, Abraham Sweeney. Jose Perez is the officer. The case number CEMBR 2018-00121. Fine set was $250. The abatement date was May 8th of 2019.
Mr. Perez?
City of North Miami Code Enforcement Officer Perez. Today we're hearing the case in reference to the property at 12120 Northwest 2nd Avenue. The property in question is in violation of the one second.
Are we talking about the same property?
Item number 12.
Okay, got it.
5-6B, numbering of all buildings required.
Yes.
As of May 8th, 2019, the property is still in violation. The property was posted on April 23rd, 2019 at approximately 3:36 p.m. and it was also sent certified mail. Compliance has not met. The city is requesting for the fines to move forward. I also have a
ratified.
photograph. Correct.
Okay. Based on the unrebutted testimony of the city's code compliance officer, the evidence presented finding that the property has been out of compliance, and that there was an abatement date of May 8th, with a fine set at $250, I hereby ratify the fines accrued to date and assess costs in favor of the city, authorize the filing of a lien.
The next item is item 14, Alfred Golden. Shanna Sanders is the officer. The case number CERCB 2018-00227. The fine set was $250. The abatement date was March 27th of 2019. Item 14.
Shanna Sanders, City of North Miami Code Compliance Officer. This is a case for reports of previous compliance. Property address 12900 Cherry Road. As of last Wednesday, May 8th, 2019, the boat still remains. Just to give you a little history, this was a violation for having a boat parked on the property without first securing an administrative variance. So as of last Wednesday, the boat still remains parked in the front driveway and no administrative variance has been obtained for the city, nor has a application has even been submitted. I am showing proper service was given. The property was posted on April 23rd with a notice to appear. Certified mailing was also mailed out by the administrative staff on, they don't have a notation, but I'm assuming they did the certified mailing as well.
It should be attached to the notice to appear on the back.
My apologies, Magistrate Smith.
No
You
problem.
say it's
Take
on the
your time.
back?
Of the
Laura?
notice to appear.
Was it the one that says certified mailing, the one that came
Correct.
back? Okay, yes, I've seen that she did certified mailing. Well, I see here, I believe the 30th, April 30th? Yes, okay.
Is that it?
You actually, when was it originally cited? Oh, yes, I'm sorry, you said is that it? I'm sorry, yes, that's it.
Yeah, okay. Based on the unrebutted testimony of the city's code compliance officer and the evidence presented that the property has been out of compliance since the date of abatement, which is March 27th, I hereby find in favor of the city, ratify the fines accrued to date, the fine amount being $250, and assess costs in favor of the city, authorize the filing of a lien.
The next case is item 15, Alma Invita Trust. John Dorville is the officer. Case number CEFAW 2019-00012. The fine set was $250. The abatement date was May 8th of 2019. Item 15.
Good afternoon once again.
Good afternoon.
This is a property. This is actually CEFAW 2019-00012.
Correct.
Thank you. Proper service was given on 4/22/19 at 2:43 p.m. This is in reference to a fence on the actual east side of the property that has been damaged and not repaired. I've had no contact with this particular property owner. I've posted several times. Certified mail was returned, however. I have pictures. My last inspection was the same date as the posting.